Report of the Center-State Relations Inquiry Committee, 1971, Rajamannar, Government of Tamil Nadu, read by Ramani, Chapter 3, Administrative Relations. The executive power of the state is coextensive with its legislative power, Article 162. In other words, the executive authority of the state is exclusive in respect of state subjects. It extends to concurrent subjects also, unless other provision is made in the Constitution or in an act of the Parliament. It goes without saying that the state has no executive power in relation to union subjects. Article 298 also is relevant here. Under this article, the executive power of the state extends to carrying on of trade or business and to the acquisition, holding, and disposal of property and the making of contracts. This amplitude of executive power of the state is curtailed by the other provisions of the Constitution. The provisions which impinge on the executive authority of the state enable the Union to effectively assume to itself, that is, the Union, the executive powers of the state. The two articles which magnify the power of the Union are Articles 256 and 257. Issue of directions to the states by the Union. Articles 256 to 261 deal with administrative relations between the Union and the states. Articles 256 and 257 empower the Union executive to issue directions to the state governments to ensure that the latter comply with and do not impede or prejudice the laws of the Union or the Union executive in the exercise of its authority. The two articles are based on similar provisions in the Government of India Act 1935, sections 122 and 126. There is no precedent for the two articles in the American, Canadian, Swiss, and Australian constitutions. This power conferred on the center to give directions to the state is repugnant to a federal constitution like that of the United States and contrary to the federal principles. It appears as though that even within the sphere covered by List 2, the Union executive shall have the power to give directions to the state executive. Not only is this power so repugnant, there is the further provision for visitation of grave consequences on a state for failure to carry out such directions. Article 365 entitles the center to supersede the state government by assuming to itself under Article 356 the powers of the state government concerned. There was no provision in the draft constitution for securing compliance with directions issued under Articles 256 and 257. It was only at a later stage that Article 365 was inserted in the Constitution. Article 365 highlights the subordinate position of the states. In a case where the Union is aware of the fact that its directions could not be complied with by the state, the Union could still issue directions under Articles 256 and 257 and create a situation enabling the Union to invoke its powers under Articles 365 on the ground of failure by the state to implement its directives. This obviously results in the assumption of the legislative and executive powers of the state by the Union. Viewed from this angle, Articles 256 and 257 appear to be objectionable and constitute a serious intrusion into the executive field of the unit. Even at the time of framing of the Constitution, Article 365 was denounced by several members of the Constituent Assembly. They included Pandit Thakur Das Bhargava and Pandit H.N. Hunzru. They expressed their dismay at the drastic power of the article and contended that the drafting committee had exceeded its authority by introducing the provisions when the drafting was nearly completed. Article 365 was introduced just 11 days before the Constitution was adopted by the Assembly. Other opponents of this article complained that it resembled the hated Section 93 of the 1935 Act, caught in all its nakedness and horror, unquote. However, ultimately, Article 365 was adopted by the Assembly. It's Article 365 which renders Articles 256 and 257 most objectionable. These articles are unprecedented and affect the autonomy of the states. Article 257 authorizes an executive encroachment on a parliamentary function. Dealing with the provision relating to communications under Article 257, Thiru Ashok Chanda remarks as follows: Court, in the distribution of jurisdiction between the Union and the states, only such highways and waterways as are declared by Parliament to be national fall in the sphere of Union responsibility. But despite this distribution, the Union has been empowered to give directions to the states for the construction and maintenance of means of communications considered by it to be of national importance. This provision thus makes it possible for the Union Executive to arrange for the construction and maintenance of means of communications without invoking the legislative powers of Parliament for their formal declaration as national. The purpose of this executive encroachment on a parliamentary function is not very clear, unquote. It may be also noticed that though there is an obligation imposed on the states not to prejudice the exercise of the Union executive power, there is no corresponding declaration imposing an obligation on the Union not to prejudice the exercise of executive power of the states. Two courses seem open. One is the omission of Article 256 and 257 in their entirety. Another alternative has been suggested by Thiru R.S. Gai, Secretary to the Government of India, Ministry of Law, Department of Legal Affairs. In his article captioned Administrative Relations Between the Union and the States, published in the October-December 1969 issue of the Journal of Constitutional and Parliamentary Studies, he has suggested that Parliament could, in a case where the state has failed to carry out the directions issued to it, pass a law empowering the central government to call upon the state ministers and the authorities of the state to implement the directions issued by the central government and imposing a penalty for failure to do so. He is in favor of invoking Article 258(2) to achieve this purpose. According to his suggestion, the state legislature and the state cabinet could be continued. The state cabinet could continue to hold office, but the position will, in some respects, be worse than what would obtain in a situation where Article 356 is put into force. The state cabinet is collectively responsible to the Legislative Assembly, which would continue to function in the situation contemplated by Thiru Gai. What's to happen if the state legislature expressly prohibits the ministry from implementing the directions of the central government? Apparently, according to the Union Law Secretary, recourse could then be had in Article 365 and consequently to Article 356 if this contingency fructifies. In short, according to him, the state cabinet would be subject to the control of two masters and should be responsible to both, namely the central government and the state legislature. This is an impossible position. Further, in dealing with the legislative powers, we have suggested modification of Article 258(2) to provide that Parliament should not confer any power or impose any duty on the state except with the consent of the state. Therefore, the only alternative in case Articles 256 and 257 are to be restrained is to provide that no direction as contemplated in Article 256 or 257 should be issued except in consultation with and with the approval of the Interstate Council to be constituted in the manner and with the functions suggested by us below. In any view, we recommend that Article 365 should be repealed. Besides Article 256 and 257, the following articles also empower the Union government to issue directions, and they are dealt with below. Article 339(2). This article enables the Union to issue directions to a state as to the drawing up and execution of schemes specified in the direction to be essential for the welfare of the scheduled tribes in the state. The welfare of the scheduled tribes is a matter in which the states are vitally interested, and in fact, it's the states which have to meet the expenditure involved in the welfare schemes undertaken for the benefit of these tribes. Our remarks regarding Articles 256 and 257 apply here also. Article 344(6). This article empowers the President to issue directions based on the report of the Official Language Committee of Parliament. Issue of directions in regard to language is bound to create disharmony between the Union and the states. This provision should, therefore, be omitted. We want to make it clear that failure to implement any direction issued under any article should not result in the imposition of President's rule by invoking Article 365. Interstate Council. Article 263 provides for the constitution of Interstate Council. Thiru K. Santhanam, in his paper submitted to the National Convention on Union-State Relations, has urged the constitution of the Council. Earlier, the study team of the Administrative Reforms Commission had also strongly recommended the establishment of an Interstate Council under Article 263. According to the Administrative Reforms Commission, the Council should consist of the Prime Minister, Union Ministers for Finance and Home, Leader of the Opposition in the Lok Sabha, and 5 representatives of the 5 zonal councils and special invitees. This committee recommends the immediate constitution of the Interstate Council. The proposed council may consist of the chief ministers or their nominees, all the states having equal representation, with the Prime Minister as the chairman. No other minister of the Union Cabinet should be a member of the Council. Every bill of national importance or which is likely to affect the interests of one or more states should, before its introduction in the Parliament, be placed before the Council, and its comments and recommendations thereon should be placed before Parliament at the time of introduction of the bill. It should be definitely provided that before the Union government takes any decision of national importance or any decision which would affect one or more states, the Interstate Council should be consulted. Exception may be made, probably in regard to subjects like defense and foreign relations. But even in such matters, the decision of the central government should be placed before the Interstate Council subsequently without any avoidable delay. If the Interstate Council is to be really effective, its recommendations should be made ordinarily binding on both the center and the states. If, for any reason, any recommendation of the Interstate Council is rejected by the central government, such recommendations, together with reasons for its rejection, should be laid before Parliament and state legislatures.